I'm gonna love you.
Hello and welcome dear students. Today we will discuss an important topic on concept and working of the administrative tribunals. The main objective of this lecture is to explain the concept and working of the administrative tribunals. It explains the emergence of the tribunals in the world, especially in the countries like France and United Kingdom. The shift from common law courts to the administrative courts is not a natural development, but a dire necessity. In contemporary times, the activities of the state have undergone a tremendous change, and this shift has necessitated addressing to, in addition to the law and order situation, a plethora of other activities, including the licensing, healthcare, transportation, services, etc. These wide range of activities warranted disputes determination, which emerged on account of multiplication of state-controlled activities. Initially, the concept of the rule of law swayed the legal regime, which vested the power of dispute settlement to the ordinary courts established under the law of the land. These courts had to observe the procedure prescribed by the law, which was highly technical in nature. Moreover, the litigation also became technical in nature, which required technical knowledge for dispute settlement. Furthermore, the spurt in litigation further complicated the problems of dispute determination, overburdening the ordinary courts, leading to delay in determination of a case. Secondly, the prevailing concept of separation of powers provided exclusive domain of working to the three wings of the government, that is, legislature, executive, and judiciary. These concepts inhibited the growth of the law required for the modern age and were modified to make space for new innovations and designs in legal regime. Tribunal. The word tribunal has been given several meanings. In one sense, it means a seat or a bench upon which a judge or judge sit in a court. In other sense, it means a court of justice. But in Durga Shankar Mehta versus Raghuraj Singh, the Supreme Court defined that tribunal does not mean the same thing as court, but includes within its ambit all adjudicating bodies, provided they are constituted by the state and are invested with judicial powers different from administrative or executive functions. Administrative tribunal is similar to a court in certain aspects. Both of them are constituted by the state invested with judicial powers and have permanent existence. Thus, they are adjudicating bodies deciding disputes between the parties which are entrusted to them. In Associated Cement Companies versus P.N. Sharma, the Supreme Court held that the basic and fundamental feature which is common to both the courts and the tribunals is that they discharge judicial functions and exercise judicial powers which inherently vests in a sovereign state. But it must be kept in mind that a tribunal is not a court but possesses some trappings of a court, such as a court of law is bound by precedents, principles of res judicata and estoppel, whereas an administrative tribunal is not strictly bound by them. A judge in a court of law must be an impartial arbiter, and he cannot decide a matter in which he is interested, while an administrative tribunal may be party to the dispute to be decided by it. In Bharat Bank Limited versus Employees, the Supreme Court observed that though the tribunal possesses some of the trappings of a court and though they exercise quasi-judicial functions, they are not full-fledged courts. A tribunal is an adjudicating body which decides controversies between the parties and exercises judicial powers different from purely administrative functions, and thus possesses some of the trappings of a court but not all. Thus, a tribunal must possess the following characteristics. An administrative tribunal is the creation of a statute and thus it has a statutory origin. An administrative tribunal is entrusted with the judicial powers of the state and thus performs judicial and quasi-judicial functions different from administrative or executive functions and is bound to act judicially. An administrative tribunal is not bound by strict rules of evidence and procedure. Administrative tribunals are independent and they are not subject to any administrative interference in the discharge of their judicial or quasi-judicial functions. In procedural matters, an administrative tribunal possesses powers of a court, for example, to summon witnesses, to administer oath, to compel production of documents, etc. Necessity for creating tribunals. Administrative tribunals have several benefits and are most suited to modern day administration. Administrative tribunals, with their expertise, can help the legislature to formulate rules and regulations necessary to effectuate legislative policies. The administrative tribunals, with its informal methods, is much better adopted as the development of social control of private affairs on a wide scale has required the formulation of the rules of action in new fields of governmental activities, where the precision rules of action to be enforced is not apparent and where careful experiment is necessary. Hence, a measure of flexibility is desirable. Regular judicial systems are unsatisfactory mechanisms for the adjudication of certain types of controversy arising in the current social and economic order. Judicial procedure has proved to be too slow, too cumbersome, too costly, and inapt in certain fact situations to satisfy modern need. The judiciary, excellent though, is for the purpose of disposing of purely private controversies and is not well adapted to deal with the controversies of social content, in which general public welfare becomes a significant factor. The administrative tribunals fit into a system of regulation in the general public interest much more effectively than does the judiciary. The government, both at state and national level, develop new services which they render for the public as they discover new needs of government boundaries. Administrative tribunals well make their appearance or agencies in aid of administration. Since the tribunals are not bound by the technical procedure and have only to observe principles of natural justice, therefore they can render speedy justice to the parties. Evolution and development of tribunals. The concept of tribunal in its present form was adopted by all the countries of the world from French system. The classification of separate courts of administration proved out to be very effective in regulating and adjudicating administrative disputes effectively and quickly. Therefore, it became imperative for all the nations to adopt the French model on account of the spurt in the activities of the administration and its impact on the national populace. Tribunals in France. French administrative law, or droit administratif, is a branch of law which deals with the powers and duties of various administrative agencies and officials. According to Dicey, droit administratif is that portion of French law which determines the position and liabilities of state officials, the civil rights and liabilities of private individuals in their dealings with officials or representatives of the state, the procedure by which these rights and liabilities are enforced. According to Dicey, this system is based on two principles, namely, the government and every servant of the government possesses as representatives of the nation a whole body of special rights, privileges or prerogatives to be determined on principles different from the considerations which fix the legal rights and duties of one citizen towards another. An individual in his dealings with the state does not, according to French legal system, stand on the same footing as that on which he stands in dealings with his neighbors. The doctrine of separation of powers, according to which the judges of ordinary civil courts are irremovable and thus independent of the executive, the government and its officials are independent of and free from the jurisdiction of the ordinary courts. This political instability has contributed to the undoubted stability of the French administrative machinery, as the Council d'État, like the prefects and mayors, has survived two monarchies, two empires, and 4 republics to give France very considerable internal stability. Conseil d'État. In the pre-revolutionary France, the Conseil du Roi advised the king on legal and administrative matters. With the coming of the revolution in 1789, a major break was made with tradition, and thus Conseil d'État was created, which had certain early resemblance to the Conseil du Roi of the ancient regime, but there is no direct link between the two. The first step taken by the revolutionists was to curtail the powers of the parliaments. This gave complete liberty to the administration, as the powers of the king was curbed and the Conseil du Roi was abolished. Napoleon, when he assumed power as first consul, was conscious of the value for administrative reforms. Therefore, he favored freedom for the administration and wanted expert advice on the drafting of the laws and regulations. He established a Conseil d'État which was to operate under the direction of 3 consuls. The main aim of the institution was to resolve difficulties which might occur in the course of the administration. It was divided into 5 sections, and their work was initially to draft new laws and administrative regulations and to resolve difficulties which might occur in the course of administration. Although acting on appeal against the decision of the minister, the Conseil d'État had no power actually to decide or to pronounce judgment. Rather, its job was to advise the head of the state as minister's superior in the administrative hierarchy. It was this aspect of the Conseil d'État which was against Dicey's concept of rule of law. By the close of 19th century, the Conseil d'État emerged as a court of first instance, having a general jurisdiction to be seized directly by any complaint or suit against the administration. Role of the Conseil d'État. It is necessary that all bills introduced into the Parliament by the government must have been submitted for the Council's advice, though it is not necessary that the advice must be followed. In principle, it cannot present to Parliament a bill containing provisions which conform neither to its original bill nor to the modifications suggested by the Conseil d'État. The Council's advice on bills is normally given by the General Assembly of the Council after an initial examination and report from the appropriate administrative section. Apart from the legislative process, the Conseil d'État has the duty of acting as a general legal advisor to the government and to individual ministers. Development of tribunals in United Kingdom. Britain has a long history of extrajudicial remedies for the grievances of the ordinary citizen, whether those grievances be against the state or fellowman citizen. The established judicial system has never been fully comprehensive in the provision of the remedies for all possible types of wrongs and injustices. In the 14th century, when a litigant could not obtain redress in the ordinary common law courts, it was open to him to petition the king personally. Later, because of the increase in the number of such petitions, a whole department, in fact a court, was set up to consider them. This was the Court of Chancery, which started life to provide more convenient and often better alternatives to the existing courts of law, and it brought a fresh approach to the problem of dispensing justice untrammeled by the adherence to strict rules of procedure and precedents. The converse method of employing judicial officials to perform administrative tasks is seen in the Office of Justice of Peace, originally established to exercise a criminal jurisdiction, a function which they still retain. But from 1361, they were called upon to exercise administrative functions as well as their criminal jurisdiction, and in the first great period of social control in England, the reigns of the Tudors, they were the chief instrument by which the whole Tudor system of regulation was put into operation. The Tudor tribunals were set up for providing remedies where the courts would not. Although in the less principal age it was almost inevitable that they should not come to be used as extension of the government of the day. The Star Chamber provides a closer parallel with modern administrative tribunals. The Star Chamber have been instituted as a political means of maintaining the power of the Tudor monarchy, and its efficiency quickly made it a popular alternative to the ordinary courts. Having developed at a time when the main purpose of the legal system was to relieve the burdens and protect the privileges of the landowners, they were certainly ill suited to the interests of the new merchant class which was developing under the Tudor. Thus, administrative tribunals have found their way back in the judicial system after the Industrial Revolution of the 19th century and the changes and movements of the political and philosophical ideals that accompanied it. Professor Wade described in his evidence to the Franks Committee as the tangled picture of the special tribunals and quasi-judicial procedure is largely the result of the unsystematic attempts of Parliament to fill what is really a lacuna in judicial system. The Tribunals and Inquiries Act 1971 gave the Council power to make general recommendations as to the membership of tribunals and gives it a consultative role with regard to the procedural rules for tribunals and for statutory inquiries. The Council on Tribunals was set up in the wake in response to a haphazard growth of administrative justice and at a time when there was a widespread view that the courts of law no longer had the capacity or the resilience to wrestle with modern issues of the law and the state. The Council on Tribunal began without fanfare, and its first report was greeted in 1960 by what was described as resounding apathy. With this, we come to the end of today's lecture. Hope you have enjoyed